Good afternoon, everyone. Mark Westcott here, and g'day, Juanita.
Hello, Mark.
Are you there, Juanita?
Yeah, hello, Mark. How you going?
Okay. Can't see Juanita moving, and we better end this. Hi, everyone. Mark Westcott here, and we've just got some technical issues today. So, if you could please bear with us for 1 second, that would be great. Juanita's going to be with us here any second, as soon as I add her in. So, hey, Juanita.
Hey, Mark. How you going?
Anyway, I'm up in Longridge today, and we've been doing Tom McVeigh and I have been doing a tour. So welcome, Juanita. I'm really struggling to hear you, so I'll ad lib and then I'll hand over to you. But no, Tom McVeigh and I have been up travelling through central Queensland. We've been to Boulia. Yesterday we went to Emerald on Monday, and today we're in Longridge. And I'm suspecting that the Wi-Fi here in Longridge isn't strong enough to carry the signal between Juanita and myself. So I'll hand over to her in a second. But the topic is what happens if you die without a will, or die intestate, or some people call that interstate, but no, it's intestate. And so Juanita, fire away, and maybe you just stick your hand up or something when you've done your part, and I'll try and comment if I can hear.
Sure. So the topic today, as Mark said, is what happens when someone dies without a will. And that's what we call if you die intestate, without a will. So I'll go through a few of the different steps and scenarios. The first thing is the same as when we do have a will, and that's make sure that everyone's okay, and then make plans for burial and funeral, etc. So it's those personal things that need to be done first. Sometimes there can be disputes arise around this time, however, which I'll touch on later, which cause the need to take different steps as such. But once those first steps have been undertaken, I guess the next question is who is to look after the estate administration. So obviously when we have a will, we have an executor and the person is named in the will. However, when we don't have a will, there's no one being appointed. So usually in an ideal world, we won't have any arguments or disputes, and we'll have a logical person, a next of kin. It might be a spouse, for example, that can handle the deceased affairs. Again, at this stage, sometimes we'll see disputes arise as to who that person should be. And that's one of the circumstances where someone might have to apply for what we know is called a grant of letters of administration. And I'm going to touch on that a bit more shortly. Another reason why we might need a grant of letters of administration, which is similar to a grant of probate if you've got a will, is if there are assets over a certain dollar value in the estate. Now, if the assets are only minor, we might not need to get a grant, and the estate can be administered informally. But and Mark's just nodding along. He thinks he can he can't hear what I'm saying, but he's trusting that I'm making good sense. So it's in some cases we'll need to apply for a grant of letters of administration, and that is where someone applies to the court to be appointed the person who will administer the estate. Now, there's a pecking order, and the law provides for that pecking order. So, in order of priority, the person who can apply to be the administrator of the estate is the spouse, the children, the grandchildren, the parents, the siblings, and so it goes on down the track. Now, a person on a level below can't apply unless the people in the level above have disclaimed their right to do so. So again, it depends on the particular scenario, and hopefully there's no disputes, because that's again a place where we'll often see disputes come into play. Another question that we'll often see or hear when someone has died without a will or died intestate is, how is the estate distributed? And the answer to that is the estate is distributed pursuant to the law. And now this is a reason why you'll have heard us say before, it's a good idea to have a will, because at the very basis of it, you can nominate who you want to receive your assets in your estate. If you don't have a will, you get no choice. So the assets are distributed by what the legislation says, what we call the Succession Act, and that is, again, a pecking order. So in a situation where there's a spouse and children, there's a formula which depends on the different scenarios. So the formula will depend on how many children, how many spouses. In some cases, we have seen there's more than one spouse. And